All right, it's time for another definition on the North Carolina Real Estate Show, and today we are talking about deed of trust. What is the legal definition of a deed of trust? It is a security instrument in which the borrower, under a promissory note, pledges real estate as security for repayment of the money to the lender. That's a mouthful. What does that really mean in plain language? It means someone has borrowed money to buy a house, and they have agreed that if they don't repay the money, then the lender can foreclose and get the house. If you're sitting at my closing table, then you have heard me say in the past, or you will hear me say when explaining this, is it means if you don't pay, you don't stay. You only get to keep the house if you're actually making the payments on it. So the lender retains the right to take back that asset if you're not paying them the money that you borrowed. So a deed of trust often gets confused with a deed. They're not the same thing. Deed is legal title to the property. A deed of trust is a security instrument. And a deed of trust has three parties. A lot of people don't know this, especially if you're not from North Carolina. Not every state uses a deed of trust. Most people would call this a mortgage. But North Carolina uses the deed of trust system, and it has three parties: the borrower, the lender, and the trustee. Well, who's the trustee? They're not in the room with you at closing, almost always. Typically, the trustee is a party that's designated by the lender who will be responsible to carry out foreclosure in the event of default. Without getting too legalese on everybody, the trustee kind of holds title to the property in theory until the loan is paid off. So that's why it's called a deed of trust. So the trustee is entrusted with holding title conceptually to the property. So the borrower, once they have paid off the loan, the deed of trust gets canceled. There's no more encumbrances from that lender on the property. So you get clear title, or you get the title to your property back. That is an unnecessarily complicated thing to explain to clients because it's all very theoretical. When you buy a property in North Carolina, you get the deed right away. So there's nobody holding on to your deed until you've paid off the loan. I get a lot of questions from people like, I paid off my loan, when do I get the deed? You got it when you bought it. So you're not getting the deed mailed to you by the lender after the fact. What's happening is that deed of trust is being marked satisfied in the public record. So for most people, considering a deed of trust like they would a mortgage is sufficient enough to help them understand what's really happening. They're giving the lender the right to foreclose if they don't repay the loan. So that's what a deed of trust is. Hopefully that explained it a little bit. Again, if you remember that it means if you don't pay, you don't stay. There's also some stuff in there about how you can't have a meth lab. I dare you to find it. If you get a hold of a deed of trust, let me know if you found the paragraph where it kind of suggests you cannot have a meth lab. So yeah, that's a deed of trust. Hopefully you learned something today.